Jason Watkins, and will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Watkins, in cause number 23, DCCR 0198, you're charged with the second-degree felony offense of sexual assault of a child from December 25th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I fully understand.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Understand.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, yes.
And thank you. I have to ask everyone that. And did y'all fill out the
I'm just thinking about that, we did not.
Okay, so on these documents, there is some information about sex offender registration requirements. And do you understand that as a result of this plea, that you will be required to register as a sex offender? Also, there will be another document that you guys need to sign that just has that specific information on about what those rules are. So when we're finished today, you and Mr. Rojas need to go over that, and I'll just need your signature on that as well, okay? Okay. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Watkins is not competent?
No, Your Honor.
All right, Mr. Watkins, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and y'all get that that one more paper signed for me, okay? Thank you.
He almost didn't want to sign the rejection because it doesn't say speedy trial, so it's making it. It's not an issue, but then just
Okay.
that's a big deal.
It'll be as speedy as we can make it.
She's gonna call me right back and let me know.
Okay. Hey, would you text Charlie?
Now,
I don't know if he left.
He's in
wanna-
county court too.
text him.
Oh, okay.
We're ready for him.
Okay. I just don't want him to get stuck down there
Okay.
in the middle of something and then him get iffy again. Good morning, sir. You're Lester Ballard. And Mr. Ballard, in cause number 24, DCCR 1882, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 8th of 2024. Your indictment alleges that you were previously convicted of the third-degree felony offense of stalking on June 11th of 2007, and after that was final, you were convicted of the third-degree felony offense of assault with bodily injury on a family member, and that's from October 22nd of 2010. What that means is that if you go to trial and you're found guilty and those 2 prior convictions are true, then you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am, I do.
And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be on count 1 only. to count one only, which is the second-degree felony aggravated assault that you're charged with. And it would be for a cap of 5 years in prison, which means you would be leaving your punishment up to me. I couldn't give you more than 5 years if I accepted that plea agreement. I could give you 5, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide if you're guilty or not, and then let them decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Well, when I was speaking with him, I didn't want to sign it until I spoke with you.
Okay.
I had to sign it, or he was going to tell you that I rejected it.
Okay.
That's why I wanted to speak with you to get a clearer understanding.
Okay. All right. What do you not understand?
I wanted to get a clear understanding of speaking with you about it.
Okay.
Because there was somebody that pulled a gun on me.
So hang on. Here's the thing. I'm not going to talk to you about the facts of the case. All right. So that's what your attorney's for. That's what a jury's
I relayed
for.
all this information to the district attorney's office, and they're aware of all this stuff.
Okay. So Mr. Park, you've told him these things about what happened. He's told Mr. Smith. Mr. Smith's made his offer. You can either take it or let a jury decide. We're not going to negotiate. I'm not going to get into the negotiations because that's not the time to do it. I also don't want you to say anything on the record right now that would potentially hurt you later in a trial. Okay, so what I need to know is, do you want to accept that plea agreement for a cap of 5 years, or do you want to let a jury decide? If you didn't do it, that's what juries are for. Right? Okay, so you can't, if you plead, here's the thing, if you want to plead guilty, you're going to swear under oath that you're telling the truth. I'm going to ask you the question, are you pleading guilty freely and voluntarily? Are you pleading guilty because you did it? If you didn't do it, then that's what a jury's for. So do you want to reject that offer and go to trial?
I was asking about the speedy trial as well.
So we do not have any type of backlog here in this court. Cases are getting tried as quickly as we can possibly try them every single week. So every trial gets a speedy trial as I can possibly give it. All right?
The reason why I say, because I'm around people that say they've been there 2 years in the county. Maybe
there are different things in different cases that cause them sometimes to go longer. Sometimes it's a different court. Sometimes it's just the facts of the case. Sometimes it's DNA. But I can assure you that we will do it as quickly as we possibly can. All right. So do you want to reject that offer and go to trial, or do you want to accept the offer?
In between now and whatever the speedy trial
I don't get to.
situation is.
No, here's the thing. After today, if you place your case on the trial docket, my trial docket isn't somewhere where I put cases so that there's some more negotiation or you get a lesser deal later. Today's the day if you want to take a deal. If you don't, if it's on the trial docket, your choices are either going to be to plea open to me or to take it to trial. Because that's how I keep my trial docket moving, so that it doesn't get too big and people aren't waiting on trial for a long time. Mr. Smith, is there any reason to believe that offer would change? Okay, so the offer is what it is. Take it or leave it. What do you want to do?
I'll take it. I'll be.
I want to make sure you understand what you're going to do and say on the record, however.
Yes.
Okay?
So I might as well take it.
No, there's no might as well take it. Either you did it and you're guilty of it, or you let a jury decide. You're not going to stand in front of me and say, I didn't do it, but I'm just going to take a deal. It doesn't work that way. I can't allow you to do that. Go talk to your attorney about it, and y'all let me know what you want to do. I'll hold it for now. Okay. Where's Charlie? Okay, Charlie, y'all ready on escort? Yeah. All right, sir, you are Lester Ballard again. And looks like you've changed your mind and want to enter in a plea. Is that correct? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Ballard, in cause number, let's see, are we going on count one?
Count one. I'm sorry, Mark.
That's okay. Give me just a second to make this adjustment here. All right. The state is elected to proceed in count one only In cause number 24, DCCR 1882, it charges you with a second-degree felony offense of aggravated assault with a deadly weapon from July 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ballard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon, sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There is an affirmative finding of a deadly weapon. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You go back with the bailiff. All right, you're Christopher Bushnell. And so Mr. Bushnell has 2 cases: an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, in cause numbers 25-0112 and 0113. There was previously an agreement motion, and a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So, so we're getting close. But here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right? And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th? You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do?
Yes, ma'am.
What part of calling a correctional officer the names that you've been calling is appropriate?
It's not.
It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse, but it's not. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Or you have a little more. Good morning. Are you Marissa Tibbetts?
Yes, ma'am.
And will your client waive the formal reading of the motion in each of her cases?
She would, Your Honor.
Okay. Ms. Tibbetts, in cause number 1828, well, before we do that, raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Tibbetts, excuse me, I have in cause number 1828754, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2018 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 1828753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct? Each of these motions allege that you violated your probation. Count one in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am. Not true.
Count two in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count three in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count four in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those two are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations, and anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, you can go back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases. They're relatively high. I believe they're.
Do you want to file a motion for, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset is, can we get a speedy reset? Your Honor, or how long?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
Good morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead, no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Right.
All right. Then I have here on the computer in that case some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, that's right.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And is that your understanding of your agreement?
Yes.
The other case is, if you can't read my writing, it's extended probation and safety relapse.
Okay.
You can read it.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probate it for any number of years, you understand that you'll be waiving your right to appeal. So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause because you're already on a felony probation and there's a new felony offense. And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
Your Honor, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10, but if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in that
No
case?
objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 1523545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true?
It's true.
Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true?
It's true.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true? Count 6 alleges that you failed, nope, we're going to keep going. I want to know all of this if I'm going to consider leaving them on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025 in the amount of $1,689. Is that true or not true?
That's true.
Count 8 alleges that that doesn't really give me.
Yeah.
All right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025, and is that true or not true?
True.
Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true?
That's true.
Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Yes.
I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
Today's courtroom was a powerful reminder that every decision has consequences. Some defendants were given a second chance through probation, while others learned that repeated mistakes can quickly erase every opportunity the court offers. The judge made one message crystal clear: accountability comes first, and second chances are earned, not guaranteed. What stood out the most wasn't just the sentences, it was the warnings. Whether it was assault, firearm possession, probation violations, or bond conditions, the court repeatedly emphasized that one wrong decision can completely change a person's future. Now, here's the question for you. Do you think these defendants were treated fairly, or should some of them have received harsher punishments? Let me know your thoughts in the comments below. If you enjoy real courtroom breakdowns with legal insights and full case analysis, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next courtroom story. Thanks for watching, and I'll see you in the next case.